Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about free speech and comedy and a recent decision from the Supreme Court of Canada. The case involves a Quebec comedian named Mike Ward and a young singer named Jeremy Gabriel. Now, full disclosure, it's a case that my organization, the Canadian Constitution Foundation, was involved in as an intervener. Between 2010 and 2013, comedian Mike Ward told a series of jokes about young Mr. Gabriel, who was 13 to 15 years old at the time. Mr. Gabriel had become a local Quebec celebrity himself for his singing performances and for his story of a disability that caused facial abnormalities and required him to use a bone-implanted hearing aid. Mr. Ward told jokes about Mr. Gabriel as part of a stand-up routine about the sacred cows of Quebec. The idea of making jokes about a disabled child may strike many of us as distasteful and cruel, and Mr. Gabriel alleged that the jokes caused him serious pain and suffering. Mr. Ward was ordered by the Quebec Human Rights Tribunal and later the Quebec Court of Appeal to pay $35,000 in damages. But is it the role of government to control the types of jokes that comedians tell? According to the Supreme Court, in this case, the answer is no. Here to discuss the case is his lawyer, Mr. Ward's lawyer, Julius Gray, who represented Mr. Ward, and Joanna Barron, Executive Director of the Canadian Constitution Foundation. Thank you both so much for joining me today. Mr. Gray, congratulations on getting this result for your client. Now, can I get your initial reaction to the majority decision here?
Well, I was very happy because I think freedom of expression has taken a beating in the last 10 or 15 woke years, and everything was being canceled or repressed or controlled. And I hope this is the beginning of a comeback for freedom of expression. It's a serious step in itself, and I hope it's the beginning of a realization of just how important freedom of expression is in a democratic system.
Joanna, same question to you. Your initial reaction to the majority's decision in this case?
I thought it was a very thorough and useful, almost refresher on the rationale and value of free expression. They go into philosophers like Joseph Raz to talk about the inherent worth of freedom of expression. And of course, as you mentioned, the CCF intervened, and we were really happy to see some of the submissions we made on how freedom of speech should be balanced with other rights, which I suppose we'll get to a bit later, how those were really taken seriously and adopted by the court.
Now, Mr. Gray, one of the things that was interesting about the majority decision was that they sort of felt that it shouldn't even have got this far because there was a factual finding that Mr. Ward had picked Mr. Gabriel as a target for this stand-up routine because of his celebrity status rather than because of his disability. So how did we even get here, since obviously being a celebrity is not a protected ground?
Well, the issue is precisely that. What is discrimination? There were a number of things that were an issue, but one of them is discrimination, the definition of discrimination. The Human Rights Tribunal only has jurisdiction if it's discrimination. There was no discrimination. It's mere speech. It's extremely dangerous. And it's not just Quebec. It's across the country that the Human Rights Tribunals have been trying, I guess naturally, like all institutions, to enlarge their jurisdiction. And I think the Supreme Court reminded them that they are to be concerned with discrimination only, and not with issues of libel, which have different requirements anyway, not with being a second superior court and having general jurisdiction. So yes, that is an important thing for the whole country, not just in Quebec, to limit the Human Rights Tribunal. They did that in Watcott as well, but it seems the Human Rights Tribunals continue to try to gain ground, and I think this time it's clear they're only concerned with discrimination in the real sense of the word, and not in some infinitely extended sense.
Now, Watcott, for our viewers who don't know, is an earlier case from the Supreme Court that dealt with hate speech. Now, Joanna, your reaction to what Mr. Gray just said there, and in particular about the distinction between words and actions and actual discrimination.
Yeah, well, I think this is one of the sharpest disagreements between the majority and the minority. But the majority is very clear that there is a hard distinction between words and actions. As Mr. Gray mentioned, discrimination and the type of discrimination that human rights tribunals properly have purview over is actual exclusion from spaces, from jobs. It's actually things that actually affect somebody's material life. It's not this vague, symbolic, in the air, there's going to be an encouragement of harm ideologically.
We're going to be right back to dig into this further after these commercial breaks. Welcome back to Canadian Justice, where we're discussing free speech and comedy and a recent decision from the Supreme Court. Now, Mr. Gray, the majority here sided with Mr. Ward and with freedom of expression, but they articulated a test for discrimination. Can you tell our viewers what that test was?
Well, in general, the test was that you have to deprive somebody of some good or service or something else. The most important thing that it was not is a subjective sense of being injured or insulted. A person does not have a right not to be insulted. So words that insult and so on are not discrimination, except in the extreme cases of hate or some analogous ground. For something to amount to discrimination, you have to deprive the person of a good or service or right, other than the right not to be subjectively insulted.
Now, Joanna, one of the things the court said is exactly that, what Mr. Gray just articulated, that the test for discrimination is not about the subjective emotional experience of the person alleging discrimination. So what can you add to that point that the court made? And, you know, a lot of people have described this case as a case about the right not to be offended. So do you think that's an accurate description of what happened here?
Yeah, so I would add, in addition to discrimination is certainly being deprived of a good or a service. Certainly there's boundaries of hate speech, but there is this other sort of third scenario that I think the majority does acknowledge could be found to be discrimination, which is speech that is so debasing and degrading that a reasonable person would not tolerate themselves or other people being subjected to it. Just like, completely that encourages the debasement of certain groups within our society. And I think that they do foresee that there could be a place for a finding of discrimination there. Here, because of the contextual factors, because it was a comedy show, because Gabriel was targeted on the fact of his celebrity, it didn't even come close in the eyes of the majority.
Mr. Gray, that was one of the things that I loved about this decision was they actually did speak about the uniqueness of comedy, and they talked about the methods that comedians use and the fact that the context here was a comedy show. People knew that they were at a comedy show. So what can you tell us about the court's remarks about that?
Well, certainly when you go to a comedy show, you know that what's being said is not real. It's like when a marriage is celebrated on stage. You don't end up married to the person whom you married in the play. There is certainly that element. But comedy, there's more to it than that. In order for comedy to be successful, it has to be mordant. If you have good-natured plays on words, etc., people won't go. It's not all that funny. Comedy has to be either politically mordant or personally mordant or socially mordant. And so, in effect, I think prohibiting Mr. Ward would have put a tremendous damper. Every comedian, every comic performer would have had to ask himself, am I going to get into trouble for this? And comedy by nature is rough.
And it's interesting because when he was speaking about why he did this routine, Mr. Ward actually said because it had become impossible in Quebec to mock anyone without facing legal proceedings. And I guess he was right because he certainly faced them. Now, Ms. Barron, the CCF made some specific submissions about how freedom of expression creates an internal limit on other rights. In this case, the right against not to be discriminated against and the right to safeguard dignity. Can you tell me what the court found about these submissions about the internal limit created by free expression?
Yeah, so essentially they accepted it. They said that part of even the right to dignity, which is a Quebec charter right, not a Canadian charter right, presupposes that part of dignity is every person in society's expression has some inherent value, even if you don't like it, by virtue of fact that they are, a rational, whole human. And that essentially when we look to any type of discrimination analysis, for example, we have to start from the premise that we are in a society that values free expression as a sort of master value, a value by which we negotiate all of the other values that are important to us.
Mr. Gray, we've got about 30 seconds. How have comedians responded to this decision?
Oh, they're overjoyed. I spoke to the lawyer for their association. They think they've been freed from a threat. So I think the comedians across the country breathed a sigh of relief when the majority judgment came out.
When we come back from this commercial break, we're going to talk about the dissent in this case, which it was a closed case and there was a very forceful dissent. We will be right back from this commercial break. Welcome back to Canadian Justice, where we're discussing free speech and comedy and a recent decision from the Supreme Court. Now, Mr. Gray, in this case, it was a closed case, 5-4. There was a forceful dissent. So what can you tell us about what the dissent held?
Dissents in the Supreme Court of Canada have to be treated with respect. They sometimes contain the germ of future changes or modifications. That said, I am in strong disagreement with them. I think they put this notion of dignity and ahead of freedom of expression. If you took their judgment at face value, what it would mean is that in every single case, there would be some sort of weighing with a very strong emphasis on dignity. I think dignity is important, and dignity is important across the country, not just in Quebec. But it cannot be that everybody who wants to speak has to ask himself, are they going to come down on me like a ton of bricks because they're going to say somebody's dignity has been offended? That would mean a society in which nothing harsh, nothing critical, nothing funny can be said, because dignity is subjective, and it would do that. So I think the minority view put too much emphasis on the limits to free speech and not enough emphasis on the importance of free speech. There are limits, surely, yes, we all agree, but the importance of free speech is extraordinary in a free society.
Ms. Barron, I'd like to get your reaction as well to the dissent and what they held.
I would say that what really struck me was that everything that the four dissenting judges assessed was through the lens of prisms of power, that essentially discrimination law is meant to safeguard the rights of the powerless minority against the powerless majority. And so to them, through that lens, understandably, if you take that view of the law, everything was about safeguarding the rights of powerless Gabrielle against stronger, better platformed, deeper pocketed Mike Ward. Of course, and you can get caught up in this, but of course, we're talking about state power. We're talking about state limits on expression of free individuals, which is why I think the majority rightly points out that that would be a place to maybe file a defamation suit, a private law between individuals, not for the state to go in and police citizens' expression.
Now, Mr. Gray, this, as I mentioned, was a 5-4 decision. It was close. And do you have any thoughts on what that means for the future, the fact that this was so close?
I don't think it's going to matter very much. I mean, it is important to know, it's important to read both decisions in order to see what the debate was, and that it was a serious debate. But I'll remind you that the Amsterdam case in freedom of religion was also 5-4. And it has become the classic case now. It is cited all over the place. So I think when the dust settles, everybody will see that the majority got it right. And that, unfortunately, the minority gave too much importance to the limits and not enough to the value of free speech.
Now, Joanna, the dissent wrote a lot more about the impact of the case on Mr. Gabriel than the majority did. And I have to admit that I think Mr. Gabriel's a sympathetic a sympathetic person. So do you think that the judges in dissent here were swayed by the fact that this was a child when this happened, and a sympathetic child with a disability in particular?
Yeah, absolutely. And they talk about how, when assessing discriminatory impact, you have to sort of control for the fact that offensive words can have a disproportionate effect on children and vulnerable people. And the dissent really, it really just like evokes a lot of sympathy for not just Gabrielle, but people in his position. They talk a lot about bullying and the scourge of bullying. And I found that very telling because, again, nobody disagrees that bullying is a horrible phenomenon and that everybody in society should safeguard against it. But people also acknowledge that this is a matter for communities, for within schools, for within individuals, not to be essentially enshrined into public law and sanctioned by fines.
We've got about 30 seconds. Mr. Gray, your reaction to the same question about whether the dissent was very focused on the sympathetic nature of Mr. Gabriel.
Yes, absolutely. And I agree that Mr. Gabriel is sympathetic. We never fought against Mr. Gabriel as such. They gave it great importance. And that, I think, influenced the result. They specifically mentioned that he was a child, that it was so important.
When we come back from this commercial break, we're going to talk about the bigger picture of this case, including the controversy around American comedian Dave Chappelle and what it means for other comics, this particular decision. We'll be right back. Welcome back to Canadian Justice, where we're discussing free speech and comedy at the Supreme Court of Canada. Now, Joanna, this is an especially contentious time for comedians. American comic Dave Chappelle is under fire from people who have been offended by his comments about trans people during his recent Netflix stand-up special. So what do you think this case means for the future of comedy and other art forms in Canada?
Well, I think that this decision is really clear about 2 points. First, that there is a hard distinction between words and actions because the activists that opposed Chappelle's special really made the connection that it could lead to real world harm against violence against trans people. And the second is that comedy has its own rules and is its own universe, and we need to understand things in the context of it's a joke. As Mr. Gray mentioned, comedy has to have some aspect of the mordant in order for it to be funny. So I think those two things are very clear in looking at the Chappelle controversy.
And one of the things about that that's so interesting about what the dissent found in this case was they made these statements that Mr. Ward had suggested that Mr. Gabriel was too burdensome for society, that society would be better off if he were dead, sort of completely ignoring the context that this is not a man seriously calling for a child to be killed. This is in the context of a comedy show. So that was in the dissent. So Mr. Gray, your reaction to that part of the analysis in the dissent?
That, I think, was just plain wrong. Mr. Ward, part of his joke was, I tried to drown it, but he was unkillable. Well, if he had tried to drown him, this would have been a criminal case, not a free speech case. It was obviously a joke that wasn't meant seriously. And I think that is an extremely important matter. I think it's also important that you should be able to attack sacred cows. In our society, there's so many limits. Can you really, and I don't know whether you should or shouldn't, I'm just putting it abstractly. Somebody made fun of Native autonomy, made fun of Me Too, made fun of abortion, made fun of all sorts of controversial issues that have become politically correct, or sometimes for both sides. On abortion, both sides find the other side is wrong. Are you able to speak about them? I think a person in his 20s starting a career, and especially at university or in the government, is going to think twice before discussing either native, color, sexual matters. I think places like Stratford are going to think twice before staging The Merchant of Venice or The Taming of the Shrew. I think it's time to say, come off it. These are things that can be debated. Whether we agree with the current position or not, it can be challenged. Otherwise, nothing can ever be changed.
I think you make an excellent point about the chilling effect that certainly the dissent's decision, if they had won the day, would have had. Joanna, we've got about a minute left. I want to ask you about something that the majority said about jokes. And they did hypothesize that it could be possible for a joke to be so extreme or go so far that it would actually meet the test for discrimination. Your thoughts on that part of the majority's analysis?
Well, I think they tied into the concept of dignity, which is a sort of amorphous term that they call the lodestar of the whole charter. But it's essentially debasing, subjugating, just deeply dehumanizing. I assume that it's the type of thing that you know it when you see it, that really just encourages general social attitudes that there are certain people in society that are not worthy of even our basic respect, that are subhuman, essentially. And I'm not sure exactly what that would look like, but I don't think in either the Chappelle instance or the Ward instance that we're anything approaching that.
Yeah, certainly it's possible to accept that that is a possibility, hypothetically, but it certainly was not the case here, no matter how sympathetic the claimant was in this case. I want to thank you both so much for joining me today. And Mr. Gray, congratulations again.
Thank you.
We've heard today about the debate about when a joke goes too far and whether the government can step in and stop people from telling offensive jokes. It looks like following this result from the Supreme Court, there is no right not to be offended. But the case was close, just one judge away from a very different result. What would that have meant for freedom of expression, especially artistic expression? How do you feel about the jokes that this comic made? And what do these jokes say about our society? What's the best way to protect vulnerable people while still protecting freedom of expression? You be the judge. Thanks for tuning in, and remember, a freer Canada starts with you.